Bismillahirrahmanirrahim. Assalamualaikum and good day. My name is Zainab Zahra Binti Muhammad Amin, and I am presenting this case study for Professor Madya Dr. Haji Muhammad Shanawi bin Haji Muhammad Firuz for INC 500 Industrial Relations, Regulations and Cybersecurity. The case I chose is Swee Khoon versus Zainab Berhad, reported at 2000, Volume 2, MLJ, page 600, decided by the Court of Appeal in Kuala Lumpur. This case deals with constructive dismissal, how much detail you actually need in your pleadings, and how far a court can go when it reviews an industrial court award. Over the next 15 minutes or so, I'll walk you through the facts, the legal issues, the judgment, and my own analysis and critique. Before the facts, let me explain why I picked this case. It confirms the twofold test the industrial court must apply for constructive dismissal under Section 20, Subsection 1 of the Industrial Relations Act 1967. It also settles a really practical question whether a claimant needs to plead the exact legal label of their claim or whether pleading the fact is enough. It draws a firm line around certiorari, making clear a reviewing judge cannot simply reweigh witness credibility as if they were hearing an appeal. It applies the well-known Wong Chi Hong repudiation test to a real corporate restructuring dispute involving a senior executive, and it's still being cited today, including in a 2023 Court of Appeal decision, CIMB Bank versus Ahmad Sohairi. So this case really sits at the intersection of employment law and administrative law. Let me introduce the parties. The appellant or claimant is Swee Khoon, a long-serving senior executive at Samdabi, earning around Ringgit Malaysia 9,850 a month. He held the position of controller, processing, and was in charge of all the group's palm oil mills, with subordinates reporting directly to him. The respondent is Zainab Berhad, the employer, a major plantation conglomerate. In 1993, they restructured their reporting lines, and Quah said this stripped him of his authority and effectively lined him up alongside his own former subordinates. Below both of them sits the Industrial Court of Malaysia, which originally found that Quah had been constructively dismissed without just cause. That ruling was later quashed by the High Court before eventually being restored by the Court of Appeal. Let's walk through what actually happened. On the 6th of August 1993, Samdabi actually sent Quah a memorandum with a new organization chart attached, streamlining the reporting lines for the mills. Quah saw this as a downgrade of his post and also his job functions. On the 20th of August, he wrote a formal letter of complaint calling on the company to rectify his rank by the 24th of August and warning that if they didn't, he would consider himself dismissed with effect from the 25th. On the 24th of August, he met the general manager, Mr. Lee Yu-Fong. Lee later testified that Quah was verbally assured his position would be restored, though Quah disputed that this assurance was ever actually given in those terms. With no formal rectification in place by his own deadline, Quah walked out on the 25th of August, treating the company's conduct as a repudiation of his contract of employment. Now, let's trace what happens next. On the 1st of September 1993, the company's divisional director wrote to Quah, treating his walkout as what they call abscondment and demanding 3 months' salary in lieu of notice. Quah only actually received that letter on the 2nd of September, and a separate memo confirming the early restoration promise on the 3rd of September, by which point he had already gone in to surrender his company car. Quah then lodged a complaint with the Director General of Industrial Relations, and the minister referred the dispute to the Industrial Court under Section 20. On the 6th February 1997, the Industrial Court found that Quah had been constructively dismissed without just cause and ordered his reinstatement plus back wages. Samdabi wasn't satisfied, so in 1998, they obtained an order of certiorari from the High Court in Kuala Lumpur, quashing that award on three separate grounds. Quah then appealed, and on the 23rd of February 2000, the Court of Appeal unanimously allowed his appeal, restoring the Industrial Court's original award. So, what did the Court of Appeal actually have to decide? I've actually broken it into four issues, matching the three grounds the High Court had relied on, plus the underlying questions about the certiorari. First, the pleading point: did the Industrial Court decide the case on a ground that was never actually pleaded? Second, the correct test: did the Industrial Court actually apply the right legal test for constructive dismissal under Section 20, subsection 1? Third, perversity or preference: was the Industrial Court's decision to believe Quah over Samdabi's witness genuinely preserved, or just a factual finding a judge happened to disagree with? And fourth, the limits of certiorari: did the High Court actually exceed its proper boundaries by exercising what was really an appellate function? These four issues structure the rest of my presentation. Let's start with the pleading issue, which I find genuinely interesting. The High Court's view was that the Industrial Court had proceeded on an unpleaded case because it relied on a breach of an implied term of trust and confidence, and that specific phrase never actually appeared in Quah's statement of case. The High Court treated this as a jurisdictional error on the basis that Samdabi was never properly put on notice of that particular legal theory. So the Court of Appeal firmly disagreed. It held that every material fact behind the implied term argument had already been pleaded in detail. The downgrading, the reporting line changes, and also the loss of status. Only the technical legal label was missing. Drawing on older authorities, Lever Brothers versus Bell and KEP Muhammad Ali versus KEP Muhammad Ismail, the court confirmed it's simply unnecessary to plead the exact legal result that inevitably follows from a clearly pleaded set of the facts. Pleading exists to prevent surprise, not to test the claimant's command of legal terminology. Now, let's look at the two remaining issues together because they are closely connected. On the correct test, Section 20, subsection 1 on the Industrial Relations Act requires the Industrial Court to ask two things. First, whether there was a dismissal at all, meaning was the employee actually driven out or did he leave voluntarily? Second, if there was a dismissal, whether it was with or without just cause or excuse. The Court of Appeal held that referring to a breach of the implied terms of trust and confidence drawn from the English case Woods versus WM Car Service was really just a shorthand way of applying the established repudiation test from Wong Chi Hong versus Cathay Organization. So, the Industrial Court had, in substance, asked itself exactly the right question all along. Now, on certiorari, here's where it gets interesting. The High Court judge had gone further and actually reassessed which witness he believed, Quah or the company's witness, and then labelled the Industrial Court's preference for Quah's evidence as perverse. The Court of Appeal held this was really an appeal wearing in disguise. In certiorari proceedings, a judge must accept the industrial court's findings on witness credibility unless they're so unreasonable that no tribunal could possibly have reached them. Simply disagreeing with a factual finding is not the same thing as that finding being perverse. So, what did the Court of Appeal ultimately decide? Actually, the appeal was not was allowed. Sorry, the appeal was allowed. The High Court certiorari order was set aside, and the Industrial Court's original award was restored to file. With costs awarded to Quah both in the Court of Appeal and in the proceedings below. Let me walk through four key holdings. First, the Industrial Court did not decide an unpleaded point since all the material facts were pleaded and only the legal label was missing, which isn't required. Second, the Industrial Court applied the correct twofold test under Section 20, subsection 1, asking whether there was a dismissal and whether it was with just cause or excuse. Third, a court exercising judicial review cannot exercise appellate powers, disturbing findings on fact based on witness credibility simply isn't open to it in certiorari proceedings. And fourth, calling a finding perverse merely because a judge personally disagrees with it is not a valid ground for quashing an industrial court award. Now, for my own analysis, starting with what I think the Court of Appeal got right. First, this is generally sensible, substance over form approach to pleadings, requiring only the material facts, not the precise legal label, keeps the process practical for lay claimants at the industrial court while still protecting employers from genuine surprise. Second, I think anchoring the whole analysis is the clean twofold section 20 subsection 1 test gives everyone a predictable framework and tying trust and confidence back to the established repudiation test avoided creating a confusing new standard. Third, this judgment acts as a really important check on judicial overreach. By firmly separating certiorari from appeal, the court protected the industrial court's specialized fact-finding role from being quietly overridden by a reviewing judge's own personal view of the evidence. And fourth, I'd say this genuinely protects vulnerable claimants from technical traps. Quah wasn't punished for using plain language instead of precise legal terminology in his pleadings, which is a real practical win for access to justice. Of course, this decision isn't without its problem. My biggest concern is that the pleading line the court drew is still genuinely blurry. The judgment doesn't tell us exactly how much factual details is enough to imply a particular legal theory, so litigants and even judges can still disagree in later cases about where fair notice actually ends and surprises begins. Second, I think employers are left facing real uncertainty when restructuring because legitimate reorganization versus constructive dismissal turns on fact sensitive impressions on humiliation and status. A genuinely well intentioned restructuring can still expose a company to serious liability. Third, there's the sheer delay here. This dispute took roughly 7 years from the 1993 walkout to the 2000 Court of Appeal decision. And by that point, Quah's reinstatement remedy had fairly limited practical value. And fourth, I point out that treating disagreement as impermissible unless a finding is unreasonable cuts both ways. It also ends up shielding genuinely weak industrial court reasoning from correction, not just legitimate factual findings that deserve deference. Let's zoom out and think about what this means for Malaysian industrial relations more broadly. First, management prerogative clearly has real limits. employers can restructure their reporting lines, but stripping a senior employee's authority to line them up with their own former subordinates can cross into constructive dismissal, even without touching their salary at all. Second, this remains a genuinely durable precedent for pleading practice. It's still the standard reference for how much specificity industrial court pleadings need, and it was cited as recently as 2023 in CIMB Bank versus Ahmad Zuhairi. Third, the law has actually developed further since this case. Later decisions like Bayer Malaysia versus Anwar Abdul Rahim refined constructive dismissal into a four-condition test covering the breach itself, its seriousness, the employee's responses, and whether there was any undue delay. And fourth, this judgment continues to anchor a really important principle in Malaysia administrative law, that certiorari reviews legality and reasonableness, and not the correctness of factual findings. So to conclude, this case confirms two things that still generally shape Malaysian dismissal law today. First, the industrial court's twofold test for constructive dismissal, whether the employee was dismissed and whether that dismissal was with just cause, is applied by looking at substance rather than legal labels. Second, a reviewing court exercising certiorari has to respect the industrial court's findings of fact and credibility, stepping in only where a decision is genuinely unreasonable, not simply where a judge personally would have decided differently. So based on my analysis, I'd suggest three things. One, employers restructuring senior roles should document their business rationale carefully and preserve authority and status, not just salary, to avoid constructive dismissal risk. Two, claimants should plead the material facts of their mistreatment clearly, even if they are not entirely sure of the precise legal label those facts support. And three, reviewing judges should apply the Wong Yuan Hock reasonableness threshold strictly, resisting the temptation to quietly reweigh credibility findings themselves. Finally, here are my references in APA 7 edition, including the Industrial Relations Act 1967, the case itself, along with the related Wong Chi Hong, Wong Yuan Hock, and CIMB Bank decisions, and two academic sources on the industrial court and constructive dismissal in Malaysia, which you can see listed on this slide. Thank you very much for listening, and that concludes my presentation for INC 500. Thank you. Assalamualaikum warahmatullahi wabarakatuh.